Hey everyone, welcome back to Adjuster Hour. I'm your host, Natalie Ariave, and today we're getting into a topic that every adjuster needs to understand. Whether you're brand new in the field or you've handled thousands of files, we're diving into coverage, bad faith exposure, and what actually happens when a claim heads toward litigation. The side most adjusters never get to see fully. And to break this down, I brought in someone who's been in the trenches on the legal side for over 2 decades, Jim Pattillo. Jim has tried more than 70 cases to verdict in state and federal courts, and he works directly in the space where coverage decisions, documentation, and file handling either hold up or fall apart. So today we're talking about what actually triggers bad faith allegations, where coverage gets misread or misunderstood, and how adjusters can protect themselves and their files in real time. This conversation is going to be direct, practical, and honest, exactly how we like it here. Jim, welcome to Adjuster Hour.
Thanks so much for having me,
Yeah,
Natalie. This is great.
yeah. Thank you so much for coming on the show. For the audience, LinkedIn brought us together. LinkedIn, if you're not on LinkedIn, you should be on LinkedIn watching the show right now. But if you're not more involved in LinkedIn, get on the train, network, talk to people because you never know what connections you're going to make. And this is a testimony right here. Jim, I'm so glad that we were able to come together and have you on the show. Take a minute and introduce yourself to the audience.
Sure. I'm Jim Pattillo. I'm a litigation partner with the firm of Christian and Small in the Birmingham, Alabama office. We are in Mississippi and Jackson, as well as our Gulf Coast office, and are handling matters and basically around the Southeast. My team does a lot of high-end litigation, coverage litigation, SIU and fraud. And one of them, we can talk about this later, but I've started early in my career trying a lot of cases, but have developed the team I work with, and that's really one of my favorite parts of my practice is getting to invest in those people.
Oh, awesome. Awesome. Well, thanks again for being here. Let's go back, Jim. Let's let the audience know, how did you get into trial work and insurance litigation?
Well, I'll go way back.
Yeah, please do.
When people say go way back, my father was a defense litigation attorney, and both of my grandfathers were also lawyers. As a matter of fact, my mother's father was Sid Herlong, who was a county judge for a while, and actually was
Oh,
served in the United States Congress and was on the Securities and Exchange Commission. So to say it's kind of in my blood is certainly accurate. When I was looking at what to do after college or next education, I kind of wanted to forge my own path and never thought I'd end up a defense litigator or
mhm.
courtroom lawyer like was in my blood. But here I am. I played sports growing up and thrive on the sense of competition that comes from that. The need to prepare and execute is something that is just sort of uh, in my DNA. And, I took that into a trial practice. I started very early in my career doing medical malpractice defense, defending doctors and hospitals. First 5 years, doing a lot of second chair trials with a really good
Oh,
lawyer to
wow.
learn from. And after that, took over a very, very small book of personal lines auto cases where I got to try a lot of wheels cases, and have just grown that over the last 20 years um, getting questions on coverage from that client and developing a reputation in that area, and eventually getting called on to represent carriers in bad faith and extra contractual litigation.
So what type of cases do you handle right now? Like as of recent?
So, my practice, the bad faith extra contractual component of
Mhm.
that, which is probably half of my practice, are post denial lawsuit is filed. I get retained as part of the defense of the lawsuit.
Mhm.
We're defending the coverage decision that's already been made, representing and protecting adjusters' interests, preparing them for depositions and testimony,
Oh, lovely.
and representing the company in litigation. Um, Another part of my practice that dovetails with that is, I do a good bit of coverage work. So if there are coverage questions, pre-decision, pre-denial,
Mhm.
pre-claim decision, I'll get involved, help with the investigation, and my team and I'll render a coverage opinion that's hopefully helpful to the carrier, to the client. That involves a good bit of special investigative unit work, working with fraud units, taking EUOs as part of the claim investigation. Um, and then, the rest of our practice involves a number of first and third party defense claims.
Do you do you feel a trend that, or is there a trend where the carriers are reaching out to you more often ahead of time to try to get a coverage opinion on the front side?
Yeah, there is, and I think,
Mhm,
and I know you've talked about this in your podcast before. Sort of there's almost a talent gap or a need for more adjusters in the
mhm,
industry. And I know you all are handling dozens and dozens of states, jurisdictions, sometimes all 50. And the workload is a lot. So I'm
yeah,
finding a lot of people calling either with a coverage assignment, carriers are developing more formal coverage programs,
mhm,
or just a quick question, pick up the phone and call. And I love those because,
sure.
I handle a very small number of states, and the people I work with are handling way more than they could possibly know. So, short answer to your question is yes, we're getting a lot more, seeing a lot more pre-suit involvement, and I think that's driving better outcomes too on
Yeah,
claims.
absolutely. I can imagine because my in my past, the when a claim has come in that automatically is triggered, okay, there's some red flags here. Maybe it's a flood on a commercial policy, and we want to, there is a specific circumstance that led to the flooding. I don't want to get into details because I don't want to, I think the claim is still open and probably we want to keep it to a minimal. But there was a special circumstance that happened, and then all of a sudden the unit flooded from surface water. And come to find out, surface water, no matter how it gets in, it's pretty much not covered, groundwater. And so I feel like having you as a tool to pick up the phone the minute we get that claim in and go, "Hey Jim, this is what I'm dealing with here. What is a good denial? What is the good denial language that we need to use to cover all of our bases?" Is that something that you're seeing where the minute they get that FNOL in, they're calling you and go, "Hey, we know we're going to deny this." I mean, are you seeing that specifically?
Well, not that quickly. I
Not
think
okay. Okay.
one of the tenets of claim handling that I think is a very good one. I'll diverge
Mhm.
into a story for a second here. I
Please,
tried
please.
a I tried a case against a former criminal prosecutor. He was acting as plaintiff's lawyer in a pretty large catastrophic personal injury case. But we got to talking, between witnesses during breaks about his prosecution practice, and he always said, the best thing I learned as a prosecutor was to try my hardest to find
Mhm.
evidence of reasonable doubt. Because if I
Mhm.
try my hardest to find it and I can't, then I know I've got a good case to prosecute. I feel like on the insurance side, that's probably good advice for claims analysts too. When you get a claim in, try your hardest to find coverage.
Mhm.
We're not looking for claims to deny. We're looking to pay what we owe as
Sure.
quickly as we can, after a fair and full investigation. So, I'm called typically not on first notice of loss, but when there is, okay, this is not an easy claim. We're not just going to pay it. We've got
Mhm.
some questions. Let's build out an investigation. Let's understand the law. Let's take an EUO. When a carrier sort of recognizes that there's a little more hair on a claim than the normal
Yeah,
one, then I think the good ones will develop a good investigation plan. A lot of times that involves getting a coverage opinion or getting some
sure.
advice on the investigation they're going to build.
No, I love that. I love that. And I'm glad we touched on that because I think that's so important now is that you want to get on the front side, you want to get ahead of it before the case goes bad, goes to litigation, unravels, and
Yeah.
then, so let's talk a little bit about more about you though. What drew you specifically to coverage in bad faith cases?
There's two concepts that we're hearing a lot these days. and those are runaway verdicts and social inflation.
Hmm.
Um, the idea that there's the plaintiffs' bars use various tactics, including the reptile theory and good old fashioned sympathy for their clients to drive these astronomical verdicts with multiple zeros on the end that really have no basis in reality. That's a problem in the industry, and what it does is it creates perception in society that because of inflation, actual inflation, because of perceptions of verdicts, perceptions of large companies, society is driving these verdicts higher and higher. And what's
Hmm.
not appreciated is that concept of social inflation and those runaway verdicts impact everyone. They raise insurance premiums, they drive insurers out of markets, which means there's less competition. And it's really a problem that I think society as a whole doesn't appreciate. So, I truly feel like, there are certainly cases that I defend where clients have made mistakes and need to pay what they
Hmm.
owe. And then a lot of times there's a punitive aspect to that. And part of my role is to advise them on here's what you're looking at. But there's another side of it that I feel I'm doing some good in defending these carriers and these companies and cases because they're truly trying to do the right thing, trying to make the right coverage call. And because of this, the culture we're in with these runaway verdicts and social inflation, it's kind of gotten a little out of control.
Absolutely. Well, I love that. Thank you for sharing that. So, what's something people assume about trial attorneys that isn't true? I love this question.
I love it too. I thought about this one a little bit ahead of time.
Mhm.
You know, Working with young lawyers and teaching them how to have a trial practice and be a courtroom lawyer. Um, One of the best bits of advice I got is I need to be myself.
Mhm.
So I need to find the parts of my personality, the parts of me that make me a good lawyer, and it's different for everybody. So I think what people assume about good courtroom talk lawyers is that they are always these big personalities who love to talk, who love to argue, who love to just be the center of attention. Um,
Mhm.
that's not always my personality. I don't necessarily always thrive in that. Most of what makes me, I think, good at what I do is long hours of preparation,
Mhm.
digging in on files, knowing a file inside and out, having a plan, and executing it. And that's the part. Honestly, that's the part about sports that I
Sure.
loved growing up: practicing, planning, and executing. Everyone doesn't have to be the biggest personality in the room to be the best lawyer in the room, and I think that's something that people
Mhm.
don't always pick up on.
Yeah, it kinda sounds like a podcast host. You don't have to be the center of attention.
Yeah,
Telling that to myself. You don't have to be the center of attention, or have a big personality to host the podcast. That immediately
that's
came
right.
to mind.
Yeah,
Yep.
just ask
No,
good questions. That's a
just
good
ask good
lawyer too.
questions.
Ask good
Yeah,
questions.
ask good questions. That's right. That's right. I wanna take a second. We have so many people tuning in. Hi, Rob. Oh, I met Rob at PLRB this week. Hey, Rob from Texas. Speaking of PLRB, I had so much fun, Jim. I'm sure you've been before, but it was my first time attending PLRB, and I was immediately overwhelmed at the amount of people at the bar that I had to find my way through the wave of people at the bar and try to talk and mingle. It was a lot of fun. Everyone was having a good time. I will tell you that. I will say that much.
That's great.
Hey, David from Oklahoma. He always tunes in. Thank you so much. My coworker Melanie from Florida. Hey, Mel. Thanks for tuning in. Oh, we have a new viewer here, Jillian from Georgia. Thank you so much for tuning in. And we have Josh from Oregon. And we have Susie. Hey, Susie. Susie's a longtime watcher, and adjuster hour original. Um, whenever we used to do this uh, at my old job, adjuster hour was every single day, and Susie tuned in just about every single day, and it was amazing. So thank you so much for being here, Susie. So let's get into the reality of claims going legal. Um, Most adjusters never really see the courtroom side, even though the claim does go to litigation. Not every adjuster gets involved in that process. Most do. Most need to get that phone call. Let's talk about what you saw, what you discovered. Let's get your point of view. But from your perspective, you know, what are the early signs a claim is heading towards litigation?
Well, I think the most obvious one is getting the letter of representation from the insured's lawyer. And you
Mhm.
can learn a lot from that. Looking at who the lawyer is, what jurisdiction they're in, their reputation, that's always helpful. Is this, and this is where you can pick up the phone and call defense counsel in the jurisdiction, but is
Mhm.
this a firm that likes to settle cases early? They handle a high volume. Do they pick small number of cases that they firmly believe in and want to push? So who the letter of representation's from, um, language in the letter, is do they talk about unreasonable delay, failure to investigate, magic words like pattern and practice sometimes
Mm.
pop up. Those letters can have a short fuse or a time demand on them.
Mhm.
So the demand letters and the sort of the language in that can always tip you off. Looking at the claim itself, one of the issues we always deal with are doctors who commonly pop up in
Okay.
litigated claims. So, are you seeing certain chiropractors or treating physicians that are frequent flyers in litigation? Um, and then the billing side of it too. If you see letters of protection and a demand, especially if you see medical. What we deal with in Alabama a lot is and most states do. You have the actual charges and the insurance paid amount with the write
Mhm.
off. Here, um, if they're refusing to give you the insurance reduction amount, the actual paid, that can be a red flag a lot of times. Because
Of course.
here in Alabama, I can't evaluate the exposure without knowing what the actual medical expenses are.
Mhm.
A lot of now aside, and I'll kind of come back to this, we are seeing a lot of plaintiffs submit and try claims without even requesting medical expenses and just trial pain and suffering. But um,
Mm.
on the first party side, I know this is big in Louisiana. Matter of fact, I had another one here just this last week. Is roofing company initiated claims.
Mhm.
So we're seeing a lot of that. You know who the players are, and if they're involved in the claim, then you can
Mhm.
possibly anticipate that it maybe end up in litigation. And then the last thing I'd say is the pattern of negotiations. If you've got a wide negotiating gap that's really unreasonable,
Mhm.
I think
Sure.
what happens a lot of times is that uh, represented claimants or represented insureds and first party claims start really high and stay there, just to see, planning on filing suit all
Mhm.
along, just to see how much they can get you to come up, without them going down, knowing that the case is going to come into litigation anyway.
Sure. So let me ask you this. If you start to notice a pattern from Dr. Dr. Smith, Dr. Smith is always popping up, always popping up. Do 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 you feel like you want to do a little more investigation into Dr. Smith and maybe get the law enforcement involved, or has that ever happened?
There was and I'm going to botch the details of it, but there was essentially it might have been a criminal racketeering case filed
Mhm.
by an insurer in California. I can't remember exactly what that was, but
Okay.
there is a little bit of pushback against some
Mhm.
collusion. I think from my standpoint, from a day to day claims litigation handling standpoint, we know who those doctors are, and we've got some good testimony from them in prior cases about how they handle letters of protection. I had one doctor admit in a deposition that, uh, in reality, if he hangs on to the bill and hopes to get paid out of the lawsuit, but if the lawsuit doesn't settle, in reality, he never gets paid at all.
Mhm.
So, and at that point, he becomes sort of personally invested in the litigation instead of just a neutral
Sure.
physician trying to solve a problem. So, and I'll get on my soapbox about this, but the more we can cooperate as a defense bar on stuff like that, the better off
Mhm.
everybody is.
What about opposing counsel? What about the relationship building between opposing counsel? Do you try to build a relationship with them so when you do get a claim across your desk or a file across your desk, you can go, okay, I know Larry. I'm going to call Larry up and we're going to try to get through this. I mean, do you make that a personal point to do?
Yeah, 100%. And really, by and large, in the states I practice in, that's the norm. I can
Okay.
pick up the phone and call most lawyers and cut to the chase. At least I hope I have the reputation of doing that.
Sure.
I know the
Sure.
ones I'm successful with in doing that, and I can say, I don't have authority to do anything. Just Jim, looking at the case, here's where I could possibly see it headed. What is your client looking for?
Hmm.
Um, knowing that most of the lawyers on the other side are a, they're friends, and then B,
Hmm.
they're people. Even if I'm not friends with them, I'm going to see them again. So
Sure.
you
Sure.
develop, and I talk to our young lawyers about this all the time. You develop a reputation
Hmm.
with the people you work with, and you want it to be a good one because it's really to your client's benefit at the end of the day. Um,
Sure.
yeah, so those are those cases that get resolved quickly and with
Hmm.
the least amount of hand wringing and headaches and work, which is what the plaintiffs lawyers want because they're getting
Hmm.
paid the same amount either way. If they can shut a case down at the right number earlier, I think the
Hmm.
reasonable ones are interested in doing that.
Sure. I can imagine that that plays a big part in your success over the years too, is building those relationships for your clients. That's awesome.
That's right.
So let's talk about what's not awesome. Some mistakes. What are the mistakes that don't look big at the time, but could cause major issues later down the line?
Well, there's some easy ones like you need to know your policy language. You need to know
Hmm.
the law of the state you're in. And I know that's difficult because, as I said
Hmm.
earlier, you all are handling many, many jurisdictions, many more than I am. Um, Documentation is always an issue. And one uh, thing that comes up frequently is us managing email. We email or Slack or however you communicate internally about cases and stuff not getting saved in the claim file.
Mm.
Every company has their guidelines about how they're supposed to manage their files and manage the claim file. But what you don't need to do is email on the side about a claim and make
Mhm.
claims decisions and comment on it and that not get saved in the claim file. Everything needs to be above board,
Mhm.
um, because what happens in a lawsuit is once the plaintiff files a lawsuit, they have the power of the court to issue discovery and enforce discovery, so they can literally force uh, an examination of your email if you won't cooperate and do even as far as like they can do word searches, term searches in your email for or claim numbers, and if something is not saved in the claim file that's in your email, that
Mhm.
can be a problem. Even if it's truly harmless, it can be leveraged against you to make it
Sure.
seem like you're not being above board with how you're handling the claim.
Mhm. Yeah. Yep.
Um,
CYA all the time.
yep. In addition to that, in claims volume, I think is a problem for everyone. So,
Mhm.
managing your workload, staying on top of things on a daily basis. Companies need to have a good backup system if somebody's out. You know,
Mhm.
being too busy is something we all fight against, but that's the kind of thing that leads to
Sure.
mistakes or inadequate documentation sometimes as well.
Of course. Yeah. It's a lot of the examiners, the desk adjusters, they are weighed down with so many files that they just don't have the time in the day to address everything that they need to, but they have to. It's detrimental to the file. So I definitely
That's right.
understand that. All right. Well, let's talk about what does a strong defensible claim file look like versus a vulnerable one. I mean, obviously we talked about that, the mistakes, but let's talk about a really strong claim file. What does that look like?
Um, Well, timely documentation, I'll keep
Mhm.
harping on that. Prompt
Sure.
acknowledgement of the claim, no long gaps in activity on the claim, where there's
Okay.
months without any communication to the insured. States have guidelines on first party claims about how often you're supposed to communicate, and being sure you're hitting those is important. Um, one thing that happens in this great awakening of the job market, people are moving around a lot, and it does not look good when you have multiple analysts or adjusters in and
Mhm.
out of a file. Whether through job change or reassignments internally. So consistency in who's handling the claim is important. Um,
Sure. Sure.
you necessary independent experts involved early is always helpful, especially if you're
Mhm.
dealing with a claim that where the cause of the loss is a concern. Maybe there's an arson defense, or
Mhm.
there's you know storm issues that they're commingled with issues of prior damage from other storms. Getting experts involved early. Um, Written coverage analysis. If you get a coverage opinion, be sure you get a legit coverage opinion. It's not a phone call to your coverage lawyer. Hey, do you have 5 minutes to answer a quick question for you? And then you're typing in the claim file as that happens. If you're going to ask a coverage question, be sure you do a full access to the investigation and to the file, and get a written coverage analysis that states the basis of the opinion, the law, and the conclusion.
No, that's
Um,
great.
Yeah, and then the other thing I think of is, time limit demands are always an issue. Be sure
Mhm.
we're promptly responding to them. First of all, timely, but second of all, if we're not prepared to agree with the demand, we need to tell them, here's what we have and here's what we need and here's how long we think it will take us to get it. So give them a real, sure enough response that's actually helpful to lay out a game plan for resolving the claim.
I want to say, Carson from Car well, not Carson from, but Carson said relationship building is the key. So there you go. There's testimony right there that building those relationships with the attorney, with the opposing counsel, is key.
Yep,
I love that.
absolutely.
I love that. Thank you so much for sharing that, Carson. Um, let's move into bad faith, triggers and coverage missteps, which, you know, that's what we're all trying to avoid. We all want, in a perfect world, our files would be submitted or submitted, and they're reviewed by the examiner, they're paid, everyone's happy, but that's just not the case. And people are unhappy for so many reasons. They just don't understand why something's denied. It's just a misunderstanding. It's not what they expected monetary wise, or maybe someone did screw up and we do have bad faith, or we do have, that can happen, that does happen. So let's talk about, what are the top three triggers you see for bad faith?
Well, unfortunately, if we lived in a world where we could pay every single claim all the time, nobody would have insurance ever because it'd be too expensive. And
Sure.
so, it's part of the job of the carrier to vet the valid claims, pay them on time, and
Hmm.
pay them in the amount they should pay
Okay.
them. But also, as we talked about, to look at the ones that should be denied, that have questions, to investigate
Hmm.
them for thoroughly. And when the biggest things that happen get outside that process, that if I'm a plaintiff's lawyer looking at a claim, or missing the time limit demands we talked about,
Sure.
not having regular communication with the insured, large
Hmm.
gaps and delays in that communication, and then just a sloppily kept claim file can
Yeah.
turn a defensible claim into one that could be potentially bad faith. Um, and then a whole other issue, you asked for sort of three of them. A fourth one is
Sure.
failing to protect the insured from excess exposure in a third
Oh.
party claim. We could talk for a whole session on that area of the law and some of the trends that are going on with that.
Oh, wow. Yeah, I didn't even think about that. As a property adjuster, I'm trying to venture out and learn more about the other sides of insurance and the other venues that, so I love that you mentioned that for those out there. Um let's talk about adjusters. some. Where do adjusters misunderstand or misapply coverage language? Where do you see that are you seeing a trend, or where do you see that the most often?
I'm fortunate that most of the companies and adjusters I work with do a really good job,
Mhm,
especially given the volume that they get. But some of the things that are sometimes leveraged in breach of contract and bad faith cases, first party cases, are, and most lawyers that are listening will know exactly what I'm talking about. Definitions and ambiguities in policies.
mhm,
Um, in most states, anything that's not defined in a policy is subject to being deemed ambiguous. And why that's important in an insurance policy is that ambiguities are almost always construed in favor of the insured. So,
okay,
for example, this is in a first party policy, if there's a theft on the premises, it's covered by a first party policy, but it's not defined in the policy, the term theft, and
mhm,
it can be interpreted in many different ways, whether something qualifies as a theft. Most states will require that interpretation of the undefined word to construe coverage in favor of the insured.
mhm,
So that's an issue adjusters need to know the policy and know the policy language. Now, undefined terms aren't by definition always uh, ambiguous. There can be some lay terms that are just clear application of normal words we use in everyday language. But knowing policy language, knowing the
mhm,
law about what terms are generally considered ambiguous in the case law, um, being aware of any public policy issues in a state. Generally, most companies' policy services are on top of state specific issues and sort of write exceptions into state endorsements and policies. I had one come up recently in the last year. It's actually on appeal in the 11th Circuit that has to do with an innocent insured exclusion. If there's an intentional act, some policy will read differently. This one read
mhm,
that uh, any insured, regardless of whether they were innocent or guilty of an intentional act, is not allowed to recover. But we had a court decide that, in their view, was void against public policy and tried to invalidate the policy provision. So knowing public
wow,
policy in the state, and these are
sure,
issues that you need to pick up and call someone in the state who has some
mhm,
expertise with. Um, and that's sort of my last point is pick up the phone and call.
mhm,
If we need to do a coverage opinion, we can and will, but you need to know your policy language and know how it's
mhm.
applied in the context of the jurisdiction that you're in.
Yeah, absolutely, absolutely. Well, let's move on to vendor, contractors, and public adjuster dynamics.
Okay.
I laugh because right now with the public adjusters, what we're seeing, a trend that we're seeing on our side of things is a lot of PAs are knocking doors because we've been so slow, and we're getting a ton of claims with data losses from last year, from last October, specifically
Oh wow.
in Florida, in the Florida region, and it's just insane. It's insane. So the PAs are resurfacing as of late. Um, so yeah, I always get a chuckle when it comes
So
across.
we don't have public adjusters in Alabama.
Oh,
Um, and I've got a case now where someone tried to act as a public adjuster, and um,
interesting.
yeah, so to me that would be a red flag that something's potentially heading for
Mhm,
litigation when you have these PAs popping up. But
mhm. Sure.
yeah, I probably could learn a little from you about how they operate and what the red flags are with them.
Yeah, we recently had one come in that was already attorney represented from the get-go from last year. So, yeah, I'm interested to see where some of these are headed. But enough about me. I'm sorry. Let's get back to the topics. Um, Going towards the vendor reports, how much do vendor reports impact the litigation posture? What are you seeing with the vendor reporting and how valuable it is in our claim file?
Uh, it certainly is important. You're talking about like if you hire independent adjusting to go look at a
Or y-
loss.
or even like an engineer's report. Owen's origin and cause report, yeah, civil engineering, even forensic accounting, I think is plays a huge part in the claim file. What are you seeing with the litigation? How important are those documents to have, and how important are they to really play out your case to the other side?
Yeah, I mean, they're huge. I mean, it's
Mhm.
part of doing a thorough investigation, right? I
Sure,
mean,
sure.
if you have an arson case, and you don't get a cause and origin person out there for 2 weeks,
Yeah.
a lot of the evidence that you would have to support your denial, however good it may have been, it could be
Mhm.
destroyed. So,
Oh,
um,
wow.
you know, having those reports and those people on the claim
Mhm.
early is gonna make the case way more defensible. Um, and
Mhm.
and using different ones, I think having more than one, cause and origin investigator is good because you really want those people to truly be like umpires in a baseball game, calling balls and strikes. They're not advocating for the company. They're not advocating for
Sure.
the insured. They're out there telling you what they see and what it means in terms of what a cause of loss or a scope might be.
Mhm.
Yeah, those are in the increasingly litigious society we are in with the large verdicts, runaway verdicts, and social inflation. Having hard evidence by experts early on in a claim investigation is crucial.
Okay. Would you recommend when there's a large loss fire, let's say $1 million plus fire, are you suggesting that we hire two or more investigators?
No, I
Mm.
don't think that's not what I'm suggesting. I'm just
Oh,
saying
okay.
that you have a number of, one of the questions
Mhm.
a cause and origin person will get in the deposition is, well, how many times have you worked for XYZ insurance company?
Sure.
And
Oh,
if he
sure.
says, well, they're my only source of business, okay, well, how many times have you found that the fire was a result of arson? Oh, about 99% of the time.
Oh, I
That
see. Yeah.
that's a problem. So,
Mhm.
for a company to have a couple of different options to go
Sure.
to, look, it helps us communicate the independence of the expert.
Mhm. Okay. No, that's good to know. That's good to know. Have that variety where you're not just set on that same investigator and then
Yeah,
you start questioning, okay, what kind of relationship do you really have with this engineer, this
yeah,
investigator? Okay.
exactly. And hire ones that work on both sides. If you've
Sure.
got good
Sure.
cause and origin investigators that often get hired by the insured's lawyers, and they
Mhm.
do a good job, don't be afraid to use them.
Yeah. No, I love that. That's good advice. So, what happens when a contractor or PA escalates the file? What should adjusters do next?
Um, Escalates in terms of it falling into litigation. I say
Just
falling, coming
Yeah,
into
let's
litigation.
let's let's say that, yeah, when they escalate the file, when they're, we're way off with our investigation found $5,000 worth of damage. The PA found 85,000, and then they start escalating either tensions, they start bringing in, okay, we're going to get a lawyer, we're going to get a litigation. What should the adjuster do to maybe bring that claim back, you know,
Well, if
back
the
down?
investigation, if the claims handling and the investigation is well done in the first
Mhm.
place, and you're
Mhm.
confident in your position that it's backed by a real investigation and real evidence, then I don't think you need to change your position just because
Sure.
someone is starting at a really high number and doubling down on it and digging their heels in. I mean, the
Okay.
claim is worth what it's worth. Now you're always going to invite more information. You make a claims decision,
Mhm.
this part of the water is from storm. This part is from flood water rising. So part of the loss is covered, part is not. You need to stick with that if your basis for that is good.
Mhm.
I think one red flag, or maybe for plaintiffs lawyers, insurance lawyers, a green flag is when you make massive changes in your evaluation and your offer to settle the case. Well, then why,
Sure.
if you think that's what it's worth, why did you offer that in the first place?
Sure, you have to be
And
careful. You gotta be very careful with that.
that can be real good fodder for them in a deposition of an adjuster in a
Mhm.
bad faith case.
Okay, yeah, so be confident in your stance. Make sure your stance is correct.
Yes.
before you die on that hill. Oh, I love that. I love
And
that.
back it up with documentation in the claim file.
Back it up. Yep, of course. Because if it's not in the claim file, it never happened.
Right.
So, I love this is what Rob said. That is a great point where claims is under more and more scrutiny to reduce expenses. So you have to have a balanced vendor network for that reason. I think that's great. That's a great point.
Yep. Yeah, and the observation, the scrutiny to reduce expenses, that's real. Sometimes we want to hire three different kinds of experts, and
Mhm.
it's just not the expense of that is not necessarily justified by the size of the claim. So
Sure.
there's some I like what Rob said because there is some discretion there,
Mhm.
um, but just realizing a bad faith case, um, reducing expenses, paying less for the good of the profit of the company, that's going to be a theme that you're going to see. So,
Sure.
you don't want to fall into that trap.
Okay, well let's give some helpful advice too. When we are having an escalation or the tensions are rising between the IA and the PA, or even on your side, when things are escalating, what tone or email phrasing can we use to de-escalate instead of ignite the claim?
Uh, well, first of all, if you're talking about an unrepresented claimant, picking up the phone is always helpful.
Yeah, I
We
love
we
that.
lose a lot in email. Now you got to document, talk to the insured, follow with an email to confirm our conversation. But
Hmm.
going back to what we discussed earlier, having that personal relationship, personal touch
Sure.
over email is important. Always invite more information
Okay.
at any point in your letter. We've reached this decision, and we're providing in a third party case, we're providing you defense under a reservation of rights. If you have any more information,
Hmm.
please provide it. We'll be glad to reconsider our position. That sort of thing.
I love that.
That Yeah. And then we all have form letters and form templates. To the extent we're able, we need to kind of get outside that. I've seen some form language slip into a letter that really makes no sense with the claim. So, that's
Mm,
just slowing down and being sure the letter
sure.
is saying what you intend for it to say, clearly explains in layman's terms, the reason for the claims decision or the reason you need something in an investigation. Uh,
Hmm.
Not just we need your EUO on February 8th at 10 a.m. Be there. It needs to be like, we've completed these things in your investigation. There's still these four unanswered questions. Um, we're going to invoke our right to conduct an examination under oath. We'll be sending you a list of documents ahead of time. If you need more time, don't hesitate to let us know. And we'll schedule at your convenience. Be human
Sure.
about it.
Be human. Yeah, I love that. I love picking up the phone too because things can just get so squirrely over email that it will escalate a situation that's not what you intended to do. So just picking up the phone and having that conversation goes a long way.
Absolutely.
All right, we have a lot of adjusters that watch our show, so let's provide them a little protection toolkit. Let's go into some of those questions. If you could give every adjuster one new habit tomorrow, what would it be?
Organize your day before it gets started. You know
Oh, I
what
love that.
Yeah, you know what's coming up. You know what time demands you have. You know what
Mhm,
meetings you have.
mhm.
So you might have 4 hours of Zoom meetings. So you only really have 4 hours today to knock out a to-do list. So I would get your day organized early,
Mhm.
and that just leads to better investigations, better documentation, and better outcomes.
Yeah, exactly. I used to give a tip out, well, I still do, but whenever people ask, at the end of the day, I take I just take about 5 minutes and I write down the top 3 things I need to get done the next day. So when I come in, I have my 3 things already written down. I can organize my day in the morning and make sure I get those 3 things done. So, I love that.
Yep.
So, how should adjusters decide when it's time to involve counsel? At what point?
Uh, Well, obviously, when a suit is filed, that's sort of
Mhm.
the latest time you're gonna call somebody. Um, Early on, if you have questions about the law of a state,
Mhm.
that can impact whether to cover something or not. But also, if you've got something that, you've got a venue you're not familiar with, or you've got a counsel you're not familiar with, those things can very much drive the value and claims decision. I will say the counsel that's been retained by the insured doesn't necessarily drive the value, but
Mhm.
it does tell you something about the seriousness of the claim, and what direction they might be headed strategically. Doesn't affect the value of
Sure.
the claim's decision, of course, but but also venue makes a big difference. Greene County,
Mhm.
Alabama versus Shelby County, Alabama is in reality a completely different universe, especially when you're talking about personal injury cases, more so
Yeah.
than more so than um, first party cases.
Yeah. Okay. Well, let's talk about AI. Mary Ann said, "Be careful. Many adjusters are using AI to write their denial and other letters, and they are not correct." So, have are you seeing this on your side of things?
It is a huge problem. I am seeing. I've
Okay.
got two claims I'm involved in early now where the insured has refused to have any conversation at all, um,
Oh.
uh, verbally, and they said I will only communicate by email. And a lot of the communication that they have initiated is clearly AI written.
Mm. Mhm.
They're asking us to tell me the law. I'm imagining what they might write as a prompt. Tell me the law in Alabama on total loss claims, and write me a letter to the insurance company about how they're wrong for denying it for this reason.
Mm.
Um, and what I'm imagining they're saying also is make this at least 5 pages long or 800 words long. It's just complete garbage a lot of times.
Yeah.
So,
Yeah.
my advice to analysts and carriers that are dealing with what seems to be AI generated claims
Mm.
communication is stick to your guns, evaluate the
Mhm.
claim on real facts,
On
and
real
be
facts.
confident in your position and stick to it. You don't have to be pulled
Mhm.
down into the weeds on all kinds of AI generated rabbit trails that really do nobody any good.
Do you think, or are you afraid that many carriers are using AI to get coverage decisions ahead of time and bypass you guys?
For a analyst, claims analyst, adjuster to use AI,
Yeah, and go,
yeah,
yeah, I have a claim. I think it should be denied. I'm going to type in AI why, and I'm going to skip the coverage counsel.
yeah,
What
that
about that?
that's that's that to me that's a huge, big fat don't ever do it ever.
Okay. Okay.
um, one problem we see with the use of AI in the
Mhm.
practice of law is that lawyers will shortcut writing briefs, and use
Mm,
Chat GPT to write something for them, and oftentimes will completely hallucinate a law or a case or a
sure.
proposition of law that's in a case. And there's numerous examples in the last year of law firms getting sanctioned or barred from practicing in a jurisdiction for
Oh,
doing that.
wow.
It is a big deal, and it is a problem,
Mhm.
um, uh, especially with all the opportunities to use AI that are being put in front of us. Now, I know there are a lot of legal databases that have an AI like overlay over their database.
Mhm.
There's some uses for that. I can use in our software that platform that we have with our legal research vendor. I can enter AI questions and it'll pull up cases for me. I know
Oh,
those cases are strictly from that database and it's not pulling from the
sure.
wider internet. But, and this is the big issue with training associates and teaching younger lawyers, is you still have to go read those cases. You still have to pull the original case to
Mhm.
see in black and white on the page that it's standing for the proposition of law or the position that the AI answer is telling you it does.
Sure.
So, that flipping back to adjusters doing that, I think that is something I could see a plaintiff's lawyer leveraging in a bad faith case for
Mm, sure.
a lot of value on their end because it can be wrong.
Mhm. Of course. Yeah, that it goes the same for adjusters. If you're using AI to look for policy language to either afford coverage or deny coverage, you still need to go look at that policy and go, okay, this is what I'm reading. How does it apply to my claim? Not how AI is saying it applies to my claim, but use critical thinking skills
Exactly.
and apply that. Yeah. Yeah. I
Yep.
love that. Exactly. But yeah, AI is such a huge it's so huge right now. Everyone is using AI technology, and I can tell too when I had a claim most recently.
Natalie, you might have frozen up on me. Oh no.
Where clearly the insured was
You're back
using
now. Yeah, there we
AI
go.
to communicate with me.
Okay.
Kind of just anyway. But yeah, an insured was using AI to communicate with me, and it was so clear because the way he talked on the phone was so different than his
Yes.
email communications. But anyway, so
Yep.
let's talk about you a little bit more. What keeps you motivated in this work?
Well, that's a great question. I really truly do love what I do.
Mhm.
Um, and part of the reason I love it is I get to work with a great team of young lawyers here at Christian and Small who've become a part of my group. We meet every Monday morning with a meeting.
Aw.
A lot of times those meetings are talking about a substantive case issue. We sort of roundtable, but a lot of times
Mhm,
they're just 2 or 3 minutes, and we catch up on each other's weekends. So I look forward to that every day, and look forward to just some of the interaction I get to have. Um, I think this is really important to remember. Great results in litigation, they
mhm,
rarely come from a single lawyer having a great day in court. They come from a team of people that have been trained, which is something that's a priority here, trusted. So we delegate them to handle real work and make decisions, and developed over years to execute in the courtroom and in cases under pressure. So
mhm.
I guess the only thing I'd add to that is if I'm the only one growing as a lawyer, my clients are not getting the best service they should get. The real value is when everyone on my team is getting better every month, thinking
Mhm.
critically. You mentioned critical thinking skills, spotting issues, owning their piece of the case, and that's when we become a real force in litigation, and when my clients get the best service available to them in a state.
I love that. So when you have a case, you're bringing in it's not just you in your case. You're bringing in other attorneys and y'all are roundtabling it, y'all are discussing it, y'all are preparing your defense. It's a team
Yep.
effort. It's not just one attorney with one case. It's really a team behind it.
Yeah, yeah. Every case in our office, by and large, is handled by one partner, one associate, and a paralegal. That's
Oh,
sort of
sure.
the team. But even beyond that, when we meet on Mondays,
Mhm,
there's quick questions. Hey, I've got a deposition with so and so. What have you worked that lawyer before? Is it easy to work with? So we have larger than just the team that's on the case. We have a team that is really, I feel like, trying to grow in the service we provide clients, and to get better, communicate clearly with them at every opportunity, and provide them good actionable advice on whatever claim they're handling.
okay. Well, where can people connect with you or learn more about what you're doing?
Well, LinkedIn is obviously how we connected. So,
Yes, sure.
I'll digress with a very, very short story. One of my partners, Todd
Please, please.
Weston, and I, when everybody went home for COVID, we went home for a short time, but we really doubled down on relationship building, and LinkedIn was a huge part of that. So, I have that LinkedIn. Thank for connecting with you and being on today. And then obviously our website is www.csattorneys.com. Um, and I'm happy to pass out my cell phone number to anybody that has a quick question, wants to call or text or anything like that too. Lots of ways to find me.
That's awesome. But yeah, find them on LinkedIn, send them a connection request. So, Jim, thank you for being here and for bringing the real side of this conversation, the backside of the litigation that we don't get to see all the time. Um, We talk a lot in our industry about handling claims the right way, but hearing how those decisions play out in litigation is that's invaluable. So to everyone watching, take these insights back to your files, your documentation, your communication, your clarity, it matters, not just for the claim outcome, but for the integrity of your work and the protection of your insureds, your carrier, and yourself. So if this episode helps you, share it, tag someone, send it to the adjuster that needs to hear it. That's how we level the industry up together. So, Jim, thank you again for joining us. Now, tune in December 4th. You will not believe we have Matthew Allen with Adjuster TV coming on. Matt has been in the industry forever, and he is the go to for adjusters, and he is going to be right here on Adjuster Hour. So, to all my adjusters out there, keep learning, keep growing, keep doing right on these claims. I'll see you on the next Adjuster Hour. Thank you, Jim.
Thanks.